Hi, this is Patrick Conway, and this is Chapter 8, Criminal Law and Procedure. Before we're dealing with civil law, into lawsuits against two people, now we're going to talk about criminal law. And here are the learning outcomes. Should be, by the time you finish the chapter, you should be able to identify and describe the parties and attorneys to a criminal action, like slide one. 2, describe pretrial criminal procedure steps before the trial. Describe a criminal trial. List and define the essential elements of the crime. Describe the most important common crimes. Describe the most common white-collar crime. Describe the rights and protections offered to suspected criminals by the U.S. Constitution and state constitution. Explain the Fourth Amendment protection from reasonable search and seizure. Describe the Fifth Amendment protections and the rights supported by the Sixth and Eighth Amendment. So what I'm going to do is I'm going to break this down into two parts. The first part we'll get through the white collar crimes. Second part, we'll focus on the constitutional protections. Okay, the parties of a criminal action. The government, be the state, can be the city, can be the federal government, represented by, they are the plaintiff, and they are represented by a prosecuting attorney, DA. And then there's the accused is the defendant, represented by a defense attorney or a public defender. Public defender is the defense attorney employed by the government. People who came with them. So, parties are the plaintiff and the defendant. Plaintiff is the state, represented by a prosecuting attorney. Defendant is the accused, and they are represented by a defense attorney or public defender. Pretrial procedures. Okay, there are the rules of criminal procedure, and then there are also the federal rules of criminal procedure. They're basically similar. Criminal actions begin with a charge against the defendant. Now, sometimes the person has been arrested, sometimes they have not been arrested at this point. They're committing a crime, they're likely to be arrested, taken a lockup, and then eventually they'll decide whether to press charges or not. If there's a criminal complaint, and that is when the government feels it has a solid case. Sometimes, the DA doesn't feel there's enough evidence, and they'll just let the person go. For there to be an arrest, there has to be shown a probable cause and warrant being issued. If there's no arrest or warrant, sometimes it's just they catch it in the act, and there's not time to get a warrant. It still has the same standard. What is the probable cause that this person did this? A bond hearing might be set in most situations a bail amendment is set. For very minor crimes, little or no bail. Major crimes, they might say this person, we're not going to trust them to not legally come. Now, there's going to be like let's say it's $100,000. Well, maybe you don't have $100,000. A bond person will require 10% of the bail. So that's why you see all the bail bonds. When your bail is set for $50,000, you only have to give the bonds person $5,000. They'll cover the rest, with the understanding that you will show up. Sometimes the actual fee that they take in the end is less than 10%. But that really all depends on bail bonds and how they feel about the case. Criminal charges are presented to a grand jury to determine if an indictment is going to be. So this is often the case where the DA actually has a grand jury to look over the evidence and they decide whether the indictment is going to be. These are high publicity things usually, and the prosecuting attorney, the district attorney is really just sort of covering their eyes. Less crimes are brought before a magistrate, like a judge, who determines if an information should be issued. Like an indictment. If an indictment or information is returned, the defendant is arraigned. That's when they take it in front of the judge and they give their plea. Common pleas are guilty, I did it. Not guilty, didn't do it, can't prove I did it, or no contest, fancy term that is no location there. They're like, oh, you say I did it, I'm not gonna fight you long. What's the penalty? The government and the defendant can enter into a plea bargain agreement to avoid the risks and costs of the trial. Things can go either way in a trial. Sometimes, even with the best evidence, you can lose. So sometimes it's a good idea to go with a plea agreement. In that case, the accused admits to guilt to a lesser crime, and the government imposes a lesser penalty of sentence. A lot of the criminal cases that plead out, I would say in our area, it really kind of depends on which parish you're in. Some parishes, juries don't like to come back with guilty verdict. Other parishes lock them up. So it kind of depends where you commit the crime. Okay, describing a criminal trial. Well, before we go to trial, the defense attorney files pre-trial motions to prevent evidence from being presented at trial. Okay, we found a kilo of coke at this person's house. So the defense attorney is going to try to make it so they can't show that evidence. And we'll cover that, how they can do that later on when we talk about constitutional protection. Now, let's say the state of the government found, came across some evidence that showed the defendant was not guilty. They are required to provide that to the defense. They can't keep it secret. And this is why sometimes some convictions have been thrown out because they find out that the police hid exculpatory evidence. All jurors hearing a criminal case must unanimously agree as to the guilt of the defendant. Louisiana, we were just not doing that for a while. And a lot of those cases are being revisited. So now everybody in the jury has to find somebody guilty. If there's not a unanimous decision to guilt, the jury is considered hung. And the government may choose to retry it or may not, depending on how expensive it was. And they can also question those jurors. How many of you voted guilty? How many of you voted not guilty? What made you, think not guilty? And they could be like, we could get 6 people to say that this person was guilty. So the chances of us finding 12 people next time is just going to be too high. Let's plead this out or not retry it. Essential elements of a crime. Crimes are classified as felonies. Those are the most serious. Those are punishable by imprisonment and typically involve crimes against the person, violence, robbery. Usually, possible prison sentence is more than a year. Misdemeanors, less serious felonies, still might be fined and punishable by a year or less in prison. So felonies, more than a year, misdemeanors, less than a year. Violations, minor infractions like traffic offenses, which are typically punishable by a fine. Now, most of these crimes are handled by state law. Because if you remember the Constitution, it really didn't deal with things like, knifing people. Or robbery. That's area left to the state to decide how they will pass laws. And sometimes what can be considered a felony in one state is not a felony in another state. Might not even be a crime. To be a crime, the person to be a crime, the person has to perform the prohibited act. To notice the actus reus, and it also says the required intent, the mens rea. There's no mens rea, that's more like an accident. Yes, I hit him with my car, but it was an accident. If I meant to hit him with the car, then it's a crime, because I have the mens rea, I meant to hit them, and I hit them. Intent crimes require that defendants have purposely, knowingly, recklessly, or negligently intended the criminal act to occur. So sometimes being wildly negligent with your driving could make it a crime rather than an accident. And most states provide for crimes that occur without specific intent. So I did not mean to kill him. What I meant to do was hold him up with a gun and commit armed robbery. He got antsy and so I shot him. But I didn't go in there with the intent to kill him. Yeah, they're going to say that they don't need the specific intent to kill them. They intended to commit a crime. And the fact that someone else ended up being killed makes it murder. You know, most states provide for non-intent or reckless conduct crimes, lesser penalty, not likely to be a felony unless it, involves like doing something while on drugs or alcohol. Strict liability crimes do not require proof that the defendant acted with intent or was reckless, only that a specific law was violated. Okay, you were well over the limit with alcohol, you struck a pedestrian. So we don't really have to determine whether your drinking caused the accident. Just enough to know that you violated that law and something occurred. In addition to criminal law, civil tort actions can be brought against the wrongdoer who caused party injury during the commission of the criminal act. So, someone will say John shot Susie in the leg. She had a lot of medical bills, she didn't die. So he can be prosecuted by the state and sent to jail. And Susie can sue him for personal injury. One of the things that makes it tricky is often criminals don't overcome. So, what's the point of suing somebody if they don't have any money for you to get this done? In other cases, it's actually easier to sue them civilly than bring criminal charges. One is what's known as the level of certainty that the jury has to come back to. In a criminal case, the jurors, all 12 of them, have to agree beyond a reasonable doubt that this person did this wrong. So it's like consider 100. Someone makes a touchdown, crosses the 100-yard line. In a civil case, the term is evidence. So, and that one is more likely than not. So it's more like they have to get to a 51-yard line. So someone can be sued civilly and lose, but not be found criminally guilty. If they are found criminally guilty, automatically they're going to be liable. Common crimes, crimes against the person, and when you physically hurt an individual or confine an individual. Murder, unlawful killing of another person. Robbery, taking of personal property by threat or use of force. Burglary, unauthorized entering of a building with the intent to commit a felony. So, the difference between burglary and robbery. In burglary, you have to go into the building. Robbery is when you do it out on the street. Larceny is the wrongful and fraudulent taking of property without the threat for use of force. So you trick them. commit fraud and get them to give you money. Theft is just the general term for taking a property of another that encompasses robbery, burglary, larceny, car theft. Big issue. Arson is the malicious willful burning of a building. Forgery, fraudulent altering of a written document. Fraud. This table. Okay. Extortion. That's the obtaining of property from another induced by actual or threatened force, violence, or fear to encourage compliance. So, I will beat you up if you don't give me this money. So this is not just robbery, that's extortion. It can also be blackmail when they first, a private person about their personal stuff. I will reveal that you had an affair with my sister unless you give me $2,000. That's blackmail, a form of extortion. White collar crime. The courts and people make a lot of difference between white collar and regular other crimes. White collar is often not penalized as badly, but there's some change in them because if someone steals $100 from me by putting a gun in my place, why should they be treated better than the person who took $1,000 from me to invest in me? That's my feeling. So that's embezzlement, taking property that was entrusted to the accused. Trusted, a lawyer or something with this money, and they took it. Criminal fraud, that's the obtaining of property through deception. Bribery, payment of money or property for favors in the return of a favor. Criminal conspiracy, agreement between two or more persons who commit a crime. So usually then you've got the conspiracy crime and the actual criminal act. It does require an overt act to further the crime, but doesn't require the actual crime to carry out. You and I discuss robbing a bank. So we're involved in a criminal conspiracy. Now, we can't be arrested until we actually take some action on that plan. Walking into the bank with a gun. Okay, so that finishes up the first part of this chapter. We'll do the constitutional protections in the next one.